Good morning, everyone. We're going to go ahead and get started right on time. It is 9 o'clock. My name is Sharon Kidman. I am the Central Office Division of Real Estate Services Realty Specialist for Hearth Act, also known as the Hearth Act Coordinator. Today, we are going to be going over the 52 IAM 13 policy, which is on the Hearth Act website. We are also going to be covering the legal sufficiency checklist, also on the website. And after the presentations are done today, we will take questions. So please be sure to utilize the chat to write down your question in there. And when the presentations are done, we will go ahead and answer those questions for you. So right off the bat, I'm going to go ahead and get started. The 52 IAM policy was first approved in 2020. And then in 2022, it went through a few updates and changes and a few tweaks here and there. But for the most part, it just had a very few small changes to it. So the 2022 52 IAM 13 policy was approved in June of 2022, and is what we're currently looking at right now on your screen. And the part that we are going to talk about is on page 5. So I'm going to jump quickly over to page 5. There are 19 pages in the policy. I recommend that when you do have time, that you go ahead and just read through the entire policy just for your own benefit. Really, today's focus is about where does a tribe begin when they want to submit their Hearth Act for secretarial approval. So the process we are going to go over today is for tribes to kind of get a feeling to ask their questions about what they need to do. But right here on page 5, beginning at submission, I won't read these verbatim, but I'm just going to kind of highlight a couple of them. So under A, submission 1, the tribe must submit a complete Hearth Act leasing regulation package to the BIA Office of Trust Services Division Chief, Division of Real Estate Services. If determined to be a complete package, then DRES, which is the short name for Division of Real Estate Services, will proceed with steps 1.7A through 1.7E of the Hearth Act process in this manual. So real quick, I'm just going to highlight A and B. I won't read through this whole slide, but A and B tell you in depth what is necessary to begin the process. It says an original cover letter that includes 1, a request for review and approval of the regulations under the Hearth Act, 2, contact information for parties with decision-making authority regarding the regulations, for example, tribal officers, legal counsel, and 3, any special circumstances regarding submission of the regulations, for instance, an urgent need for approval, a unique provision included in the regulations, etc. Item B, we need also 1 original set of the regulations approved by the tribe and signed by the authorized tribal parties, and a tribal resolution authorizing the regulation must be an original and not a copy. If the tribe submits a copy or the submission is incomplete, it will be considered as unofficial and not be reviewed or forwarded for decision until an original, fully executed regulation and tribal resolution is received. And I will say for the record that since I began doing this job in 2020, I have not ever seen originals. They were all originals. So we thank the tribes for that. And on letter C, that address was the previous address, and we are trying our best to get that corrected. But in the chat, I will go ahead and put the correct address so that you guys will know which address to send it to. It is the address in Washington, D.C. The address can also be found on the website in multiple places so that you are not misled into sending it to this address. And we apologize for that, but we will have to get that corrected. So So in regards to where do you start? So the first start is to submit in accordance with A and B of the policy. The tribe will need those three things. Also on the cover letters, if we have tribal leaders listening in today, which we mostly do, and I'm so glad that they are here today. And also the staff of the tribal realty departments who when the Hearth Act leasing regulations are approved, the tribal realty staff will then be doing their own processing for the leases, but it's good to have you folks on board today. The cover letter, we would like that it come from the tribal leader, as the tribal leader dictates to the Bureau, as this is a government to government relationship, who is their POCs. So I will be the main liaison for the Bureau of Indian Affairs. So I will be with the tribe and their POCs through the entire process. So from the beginning to the end of the secretarial approval, it will be me that you will mostly be talking with. So I will put my email address in the chat too when the session has concluded. So scrolling down after the initial submission, we do want to advise though that the initial submission should not be emailed, mailed, or hand delivered to the Bureau's regional office or agency. And then if this should occur, the field knows that they must advise the tribe to resubmit to the Division of Real Estate Services at central office. So the official 120-day review period begins only when the package is received at central office. Scrolling down, again, I'm not going to read these verbatim because it's just a very technical point to point to point of every step that we do. But basically, pages 6 covers the process, what happens. So once we receive those regulations, I will reach out to the POC listed on the tribe's letter, and I will confirm that we have received it and that I will need a copy of the tribe's regulations in Word document format. And most generally, the majority of the POCs that I have been dealing with have always given it to me almost immediately. If I send it the same day, they give it to me on the same day. So I very much appreciate that. The tribes are very responsive in getting that information back to us as soon as possible. So we thank you for that. So once we do receive that Word document version and those hard copies, we, the Bureau of Indian Affairs, begin our own internal review. And in accordance with the policy here, from the onset, we get 30 days to review internally. So if it was received December 15th, then January 15th is the 30 days ending of the review. But in addition to the 30 days, we get another 15 to schedule an internal call with ourselves to discuss our own comments. And those comments are only from the Division of Real Estate Services, the Office of the Solicitor, and the Regional Realty Office that services that tribe. So internally, those are the only folks commenting on it. So we have 30 days plus the 15 to schedule that call. So a 45-day total before the tribe is contacted, letting them know that we are done with our review. And I will say that for the most part, since the process of being centralized took place in 2020, that we've been slowly but surely cutting down that time review. In most cases, we are less than 30 days, and we notify the tribe as soon as we are done. We notify the tribe immediately and let them know that we would like to schedule an external call with them, giving them a few days if they'd like. They will tell us when they are ready to schedule that call, and we will have that call and discuss the comments with them. And so that is all part of the beginning process of the internal review and then the review itself. So I've just covered the part B, which is initial review, and then also the external call with the tribe that we do have. Now, there is a section in here called modified submission of leasing regulations. Just so the tribe knows, there will be versions of what we go through during this internal process review with the tribe, and there will be a couple of versions before we finally end up on the final agreed upon version, as we call it, between the tribe and central office. So just know that this section covers that. There's always a step by step of what we do and where it's at. And just so the tribes know that we, in the past, before there was any centralized process, I'm sure some tribes had trouble finding their packages, knowing where it was at. Maybe somebody didn't get back to them, that kind of thing. So when the process became centralized and they hired a person to do that, that person was me, then now you have a point of contact, and I respond to all emails regarding updates on the process for the tribe. So there is a section for failure to resubmit, but again, this is just a what if it happens, here's what happens. We have not really had any tribe who has not failed to resubmit. We've had tribes withdraw only due to the fact that they're just not ready, and we respect that. They may want to look at it again at another time and do it again. That is perfectly fine. We have had that happen. So we are definitely here, to listen to the tribe and to make sure that if they want to do it at that time, we're here, and then the process will go from A to Z. And if they want to reapply again at another time, they can do that as well. The final part is the final submission. Now, in the final submission, just as it was in the initial submission, you will also have a cover letter. The tribe will do a cover letter. A tribal resolution will be done accepting those modifications done through the revision, the review process, and then they will send that package in with their authorized tribal resolution for the final submission. During the final submission is where I will construct documents that will go into what's called our data tracking system, DTS, that I upload into that system, and along with the tribe's cover letter, regulations, and the resolution, and I send those forward to the other departments for review. So the package actually leaves the Division of Real Estate Services hands and will go into the system, and it will be reviewed by other departments for Asia. So once it's done doing that, then we have the end product, which is the approval, and then the posting of those regulations in the Federal Register. And a copy of the Federal Register document, the approval page, along with the regulations, will be sent back to the tribe once the process has completed. So everything has a beginning point and an end point, and I will be the contact person for all of that. So the process listed here throughout pages 5, 6, and 7 is just so that the tribe has some sort of guidance that they can look at to know where we are in that process. But you only have to email me if you have a question regarding the process or anything like that to ask me those questions, and I will gladly answer them for you. But real quick, I do want to just quickly open up the website, and I want to show that to you before we jump to our next topic, which will be the legal sufficiency checklist. So I'm going to stop sharing my screen, and I will share it again so that you guys can see the website. Okay, I'll give that just a second here, making sure that folks can see it. So this is the Hearth Act website for Central Office of Trust Services. And this website has all things Hearth related on here. There are many other things on here that in regards to Division of Real Estate Services. So all you need to do is click on this Division of Real Estate Services, and it takes you to wherever it is you want to go. Let's say you're looking for Feed of Trust or something else. rights of ways or surface leasing in general, then you can go click on there and it will take you to whatever area you are wishing to go to. But under Hearth Act, we have a page on here that goes through basically everything of what the tribe needs, what to look for. But on the right side is the extra links that you can click on. For instance, the additional information, if you click on it, it takes you right down to the bottom of the page. So the very document I was just showing you is right here. It is the 52 IAM 13 policy, and it pops right up for you. You can download that if you'd like. The next document that we will be presenting is right here, legal sufficiency checklist. That also will pop up and you can download that. If you want to look at how many Hearth Acts have been approved, you just simply click on this and they are in order by their years. If you click on that year, they are in order of the approval dates from the current to the last. And you can click on that specific one that you are looking for. And earlier when I was remarking on the address for the website, obviously the correct one is right here. Attention to the division chief, Bureau of Indian Affairs. So that is the correct address that the tribe will be sending the package to. And then most times we get questions like, well, who do we address it to? So we've put on there, because names change, people change, they come and go from jobs. So we put on there attention division chief. So people would know that that's who they are going to address it to. Right now we have an acting division chief. Her name is Carla Clark. So you are welcome to put attention division chief Carla Clark if you'd like on the cover letters. But that is the correct address, and it's also listed on another section. But for your information, the trainings that we do, these we like to call them actually overview sessions training, but it's just really an overview session of the policy itself and a how to begin process. But I want to take you to another place on the website very quickly to show you that under the Hearth Act, we do have specific trainings that are posted on our website. So under the more resources right here, you will see real estate services training. When you click on it, you're going to see Hearth Act training for tribes. This was the session that just completed on February the 7th. Today's session will be listed on here in about 2 to 3 weeks, because these sessions must be made 508 compliant before they are added to the website. But the most recent one was conducted last month and can be seen here. I also encourage tribes to go and look at this training that we did. It was just an overview. It was Hearth Act training for lenders. And this training still stands, even though it's 2024 and we did this in 2023. This still stands, and it is a very good overview session with lenders. There are some very good questions in there. So I encourage you folks to go ahead and take a look at this video at your own convenience, and then you can hear the questions also that are being asked. But there are other trainings on here like right-of-way business and that kind of thing. So, but I just kind of wanted to show you the website just so that you would know where to find these things and where they would be available for you to look at. With that said, I am going to turn part 2 of the overview session today to the Office of the Solicitor, David Moran and Suzanne Nunn, and they will go ahead and begin the next session, part of the session. Thank you.
Hello, everyone. This is Suzanne. As Sharon said, I'm from the Office of the Solicitor, and I do the Hearth Act legal sufficiency leasing along with David Moran. And we're going to go over here the sample checklist. Hopefully you can see the checklist on your screen. I am sharing it. So when we do a legal sufficiency when we do a legal sufficiency review of the Hearth Act regulations after the tribe has submitted their Hearth Act regulations to us for review, this document shows what we look for when we do our sufficiency review. The all Hearth Act regulations must be consistent with the 25 CFR 162 leasing regulations. They don't need to be verbatim, but they do need to be consistent with the 162 regulations. We understand that each tribal community is different, and so each tribal Hearth Act regulation may be different, may word things a little differently. David and I work with the attorneys for the tribes that are your POCs to come up with the language for your leasing regulations that work best for your community. So when we do our legal sufficiency review, there are 3 categories of comments that we put in the regulations. First is required. So if you see a comment on your regulations that say required, that means there are provisions or a definition that has got to be in there. It's mandatory that it's in there in your Tribal Hearth Act regulations. However, again, they don't need to be verbatim to the 162 regulations, but there has to be something addressing that provision in your regulations. The second category is strongly recommended. Strongly recommended means that it doesn't have to be, it's not a mandatory provision. It doesn't have to be in there, but as David and I see it, if we suggest something or we have a strongly recommended provision or comment, it's because it's for the tribes to create more transparency in their regulations. It's just something that we suggest. The last category is discussion. And that is if there's a provision in the Tribes Hearth Act regulations that we want to discuss as to why it's there or what the intent is of the provision or what the tribe is trying to get at with that provision, we'll discuss it on our external call and ask the tribe or the tribe's attorney to explain that to us, and then we'll discuss it from there. So on our first up on our checklist are required definitions. Now, if your Hearth Act regulations are not agriculture regulations, and you don't need agriculture land as a definition, right? So some of these may not be applicable to the type of regulations that the tribe is trying to draft or create. There are definitions in here that are not required, but that we strongly recommend, such as this best interest of the tribe definition. The best interest of the tribe definition allows the tribe to have flexibility in their regulations and to preserve their tribal decision making as an internal process. So for example, I'll use rents on residential leases. So say the tribe has a housing project and they decide that they want rent to be nominal. So in order to do that in your Tribal Hearth Act regulations, you'd have a provision when you're addressing the rental provisions. You would have a provision that says that it's in the best interest of the tribe to determine the compensation or the rent on those on their leases, and that allows the tribe to determine what the right rental compensation is for whatever their lease is. So it's, again, not best interest of the tribe is not recommended, but it is, I mean, it's not required, but it is strongly recommended. Another definition that we look for that's really important, but part of the statute, the Hearth Act statute, when it was enacted, Congress was really cognizant that they wanted the environmental review process to be public. And so it's a very important part of Tribal Hearth Act regulations is the environmental review section of those regulations. And so in part of what Congress's mandate is that the environmental review has to be public, and the tribe has to allow that public to notify the public and allow for comments on any lease activity that would directly, substantially affect that person. So we've created this definition of public for the purposes of the environmental review to be narrowly tailored to so that any Joe Schmo can't just decide they don't like what you're doing on that lease premise and decide that they're gonna flood you with negative comments and that you'd have to respond to them. This definition is narrowly tailored so that the tribe only needs to respond to any relevant or substantive comments, public comments, and this definition of public limits who that person could be, because they have to demonstrate that they will be directly, substantially affected by the lease activity. So this definition here, we've worked with a lot of tribes, actually and environmental people, to come up with this definition so that it's not so widely open, again, so that anybody can just come and say they don't like it. The person has to demonstrate that they'll be substantially affected. So that's an important definition that we look for as well. So going down this checklist, that we look for things such as the scope of the regulations, and the scope would be what these regulations are applied to, such as fee lands, individually owned Indian lands, fractionated interest, or mineral interest is what they cannot apply to. So they can only apply per the Hearth Act statute. Tribal regulations can only apply to 100% owned tribal land, tribally owned trust land. And I apologize for kind of fuddling that up a little bit and making it a little more confusing, but let me clarify. Tribal Hearth Act regulations can only apply to lands, to trust lands that are 100% owned by the tribe. It cannot apply to, you cannot use your Hearth Act lease for, or your Hearth Act regulations for land or parcels that you own partially. Say you have, the tribe has 60% interest, say the tribe has 98% interest. You cannot use the Hearth Act for those leases. It has to be 100% owned by the tribe in trust. So it cannot be fee lands. You cannot use Hearth Act for individually owned lands or fractionated interests or mineral interests. So I just want to stress that, because there seems to be some kind of confusion as to the fractionated interests. And I just want to say that if there is a parcel of property that the tribe would like to execute a lease on that is not 100% tribally owned, there is still the option of the 162 secretarially approved leases. Once you have a Hearth Act regulation, you're not limited to using just your Hearth Act regulations. You still have the ability to use the 162 leasing process. Granted, it's going to be a longer process because you need secretarial approval and BIA review, but it's still an option for you. So I just wanted to point that out. There are only a few, the types of leases that the Hearth Act are covered by are agriculture leases, residential leases, business leases, wind energy evaluation leases, wind solar resource leases, public, religious, educational, or recreational leases. So, and I'd also like to point out that, let's see, sorry, I lost my place here. The beginning of or somewhere in the Hearth Act regulations, the Tribal Hearth Act regulations, you have to state the laws that apply to these leases. Generally, what we look for is tribal law and federal law, both to be applicable. We do not suggest any state law be applicable. State law does not apply to the Hearth Act. So, but if the tribe in an agriculture lease decides that they want to apply state law to a lease dispute, then you can do that. The regulations will allow you to do that. So I just would like to point that out. We need to see a provision of what the tribe of how the tribe has the authority to enact these laws, such as the tribal constitution or the tribal bylaws. We understand that there are tribes that do not have tribal constitutions and they do not have tribal bylaws, and that's fine. We understand that issue, and we discuss that with the tribe's attorney and with the tribe, and we figure out a way to have to put a provision that satisfies this this requirement here. So let's see, let's go down a little bit. In Tribal Hearth Act regulations, tribes may discuss leasehold mortgages. You may allow leasehold mortgages, and that's up to the tribe, and how that is done is up to the tribe. But those provisions need to be in the Tribal Hearth Act code for us to review. And I'd like to note that the leasehold, that any leasehold mortgage is only on the leasehold interest. It's not on the land. You cannot encumber, or you cannot use the land as a security instrument. So just the leasehold interest, just the interest that that lessee has in that leasehold. And so the Tribal Hearth Act regulations have to provide a definite term for renewal, and definite term, and discuss if there's going to be a renewal period. Here on our checklist, it provides what those renewal options are. And I'm not going to read those out all to you, but I will state that a wind energy evaluation lease here is allowed to be a 3-year initial lease with 1 3-year option to renew. And it's just a very short time period for a wind energy lease. However, if the tribe would like to allow the wind energy evaluation lease to convert to a wind solar resource lease, a WSR, it may, you may put that in the lease language to say after the 3-year initial period, or after the 6-year period with 3 years with the 3-year option to renew, that this lease can convert to a wind solar resource lease of 25 years with up to 2 25-year options to renew. So there is that option that tribes can, that you can put in there. If there's an option to renew, you have to specify the time and the manner that that option is to be exercised, or if it's automatically effected. Any additional consideration that's due on the option, on the exercise option. Again, I'm sorry, here are the payments, the provisions. You must have rental, provide for the payment of rent. Again, I note that it may be waived if it's in the best interest of the tribe, but that has to be defined in the Tribe's Hearth Act code. You can't just say it and not define what the best interest is. So these are all, again, the requirements for the rental payments. If a lease allows for the payments to be made directly to the tribe has got to maintain documentation of those lease payments that are sufficient to enable the secretary to discharge the trust responsibility of the U.S. So that's an important provision, because a lot of tribes want their payments made directly to them, and why shouldn't they? But if the tribe got to maintain that documentation of the lease payments. The Tribal Hearth Act regulations must determine whether there's rental reviews or adjustments that are permitted. 75 years is a long time. If you do the 25 with the 2 25-year options, even 25 is a long time. So you want to be able to review the rental compensation. And so if you do, you have to have in your regulations how adjustments are made, who makes the adjustments, when they're effective. Now, I just want to note that when you put these provisions in your Tribal Hearth Act regulations, you don't have to say adjustments are going to be made by the tribal council, and they'll, be effective 30 days after. All you need to do is have the language that says the tribe will address rental reviews and will specify how, and so each lease will say, yes, we approve rental reviews, and each lease will say how those adjustments are made, who makes the adjustments, when the adjustments are effective. So I just want to point out that in your Hearth Act regulations, you don't need to give us that information. You just need to make sure that these bullet points are in your Hearth Act code, your regulations, so that they'll be in the lease in more specificity. We don't need that specificity in your Hearth Act regulations. I hope that makes sense, and I hope I didn't just confuse things even worse, but if I did, please feel free to ask at the end of the presentation any questions that you may have. There are other provisions that these are all the provisions that need to be in for lease violations for the lessee. So we need to see what the lessee's rights are, what the tribe is going to do if there's a lease violation or a trespass, or if the tribe is going to cancel or terminate the lease. What are the conditions of that cancellation or that termination? Is the tribe going to allow the lessee to cure? Is there a provision for negotiated remedies? So we look for those kind of things when we do our legal sufficiency review. There are things here. The indemnity provisions are required. They cannot be waived. This is just a standard indemnity provision for the United States, so they won't be held liable. However, the insurance provisions and the performance bond provisions, those can be waived if a tribe decides it's in their best interest. Again, using the definition that the tribe puts in their Hearth Act regulations. If the tribe decides that a lease, it's in the best interest of that lease to waive the insurance provision or the performance bond provision, that's fine. They can do that. You can do that. And then there's the permanent improvement provisions. So the permanent improvement provisions, your tribe's Hearth Act regulations have got to say if permanent improvements can be constructed, and if so, they must identify the ownership of those improvements and who's responsible for operating, maintaining, etc. of those permanent improvements. So that is, those are required in all leases except for ag. That provision is required for all leases except ag leases. We also, the Tribal Hearth Act regulations must state what happens to those improvements after the lease is done or expires or cancels. Do those permanent improvements remain on the lease premises? Do they have to be removed within a period of time at the lessee's expense, or is there some other option that the tribe wants to do to address those permanent improvements? If the lease provides for the lessee to remove those permanent improvements, it must also allow the tribe an option to waive the removal and take possession of those improvements. So it just gives the tribe the ability. It's kind of a further enforcement for the tribe when it comes to those permanent improvements on the land. We don't want the tribe to be stuck with any kind of permanent improvement that the lessee decides they're not going to take off, they're not going to remove, and then the tribe is, stuck with having that on the land and having to dispose of it at their own cost. So those provisions are things that we look for in our legal sufficiency reviews. Here are the specific mandatory requirements that must be in the Tribe's Hearth Act regulation for wind energy evaluation leases and for wind solar leases. And so each one is different. The wind energy lease has to have the testing and monitoring facilities within 12 months after the effective date of the lease, and the wind solar resource has to commence installation of the facilities within 2 years. So if you're going to consider doing wind energy or wind solar leasing, please look at these specific provisions on the checklist. And when I first began and I was talking about the public definition, these are the required environmental provisions that must be in a Tribes Hearth Act regulation. You've got to provide an environmental review process that includes the identification and evaluation of any significant effects of the proposed lease activity on the environment. Now, if you go back, and I'm going to scroll really fast, and I apologize if I make anybody sick with this fast scrolling. Here in our required definitions is the significant effect on the environment, and it's the definition of what it means to have a significant effect. So it has to be an adverse change in the environment, and it has to include all of these environmental factors. So that's what we look for in the environmental review of the in the tribal regulations. And so the tribal regulations have to identify a process. Again, as I stated before, you have to identify a process to ensure that the public is informed and has reasonable opportunity to comment on those impacts. Again, public is narrowly defined to somebody who can demonstrate that they will be adversely affected by the lease activity. So not just any Joe Schmo who decides they don't like what you're doing. And then the tribe has got to provide a provision to say how the tribe will respond to any relevant and substantive public comments. So the tribe doesn't have to respond to every single comment that it gets. It just needs to respond to relevant and substantive public comments. And it also, we look for a provision that states that if any kind of historic property or archaeological resources or cultural items that were not encountered previously or that are encountered during the course of the lease activity, that activity has got to stop immediately, and that the lessee has got to contact the tribe. They do not need to contact the BIA. The tribe could have it so that they just contact whatever department that the tribe uses to monitor or to take care of that type of those type of remains or cultural items. So and that needs to be noted also. What's the tribal program? What's the department that administers the environmental review? Who monitors it? Who determines what's a significant effect and what's not? And what happens, if there's a significant effect? If there's no significant effect, I just want to note really quickly that if there is no significant effect on the environment, then the tribe doesn't have to have a notice and comment period to the public. The only time they need to have that, you as a tribe needs to have the notice and comment period is if there is a significant effect on the environment. So I just want to point that out. And I think that does it for my tribal checklist. If anybody has any questions, again, I know I kind of went quickly through this, but if anybody has any questions, please feel free to ask at the end of this program, or I will put David and my email address into the chat, and feel free to contact us or have your attorney contact us if you have any questions on this legal sufficiency checklist. And that's it. If anybody else has anything, Sharon, I think you can take it over from here.
Thank you, Suzanne. So in closing, I will just briefly mention one more slide that we have. Now, this slide is not made available yet. It is part of a PowerPoint that we will present next week and will be in 2 weeks' time available on the Hearth Act website. But last but not least, I know most tribes have that question. What happens then? What happens? Okay, we got our approved regs. What happens? So at the end of that, it's what is BIA's role after the regulations are approved? So as far as lease review, it says the BIA does not review leases executed under a tribe's Hearth Act leasing regulations for compliance under 25 CFR 162. So there is no lease review. The approval, the secretary does not approve lease documents executed under a tribe's Hearth Act leasing regulations. Lease documents are approved by tribal authority and according to the tribe's Hearth Act regulations. Recording, and this is always a popular one, right? Per 25 USC 415 H6, tribes are to provide BIA with a copy of all lease documents, lease amendment, assignment, leasehold mortgage, renewals, and subleases for recordation. But there are, two important details to remember regarding that, and they are under the next bullet points. One, the BIA or tribe, if it has contracted or compacted the related leasing authority, is responsible for encoding lease documents. In preparation for the encoding, a cursory review should be done before entry into the TAMS system. And I want to just kind of mention on that bullet point that once the tribe is doing their own encoding and sending it forward for recording, if a mortgage document or if a TSR is needed for a leasehold mortgage, and during that, say, review of that, the title examination review for that, the LTRO finds that there is a legal discrepancy with that legal description, then it would be the responsibility of the tribe to correct that legal description. So we've had a lot of questions regarding that, and we wanted to kind of just bring that up on here and know that we do address it here in the bullet point on this slide. Second bullet point, LTRO is responsible for recording lease documents. The BIA or tribe, as described above, is responsible for submitting Hearth Act leases and lease documents to LTRO for recordation purposes after they've been entered into the TAMS system. And the last bullet, lease enforcement, violations, cancellations. Under Hearth Act, tribes will manage all aspects of those leases approved under their tribal regulations. Lessees will be subject to tribal laws. Upon reasonable notice from the tribe, the secretary may enforce provisions of or cancel a lease. And that bullet point is most often referenced in the tribe's law itself. So if not, it is in the law citation itself. The last bullet point, situations may arise that are outside of the approved regulations. For example, trespassing resulting from an unapproved right-of-way where it is still under BIA's jurisdiction to act. So we just wanted to present this slide as we have not done it before because we've had multiple questions regarding that. The BIA's role is very limited after the tribe's Hearth Act regulations are approved and they begin using it. So if the tribe requests technical assistance, they may do so from the local agency or the region, whichever one is servicing the tribe. They may do so and request that technical assistance, and the region or agency should respond. If there are any issues with that, you may contact the acting division chief, Carla Clark, whose email is referenced in the chat. She is the one that all questions are like that are fielded through. So please be sure to contact her if you are not getting the assistance requested, and she will touch base with the region. But that said, we don't have any more to our presentation today, so we will go
Sharon,
to the chat.
I just want to jump in real quick and say I forgot to say one thing when it comes to the environmental review portion of our legal sufficiency review. try to point out that when a tribe does their environmental review process, they are not required to follow NEPA. Congress specifically left out the NEPA, the stringent NEPA requirements for the Tribes Hearth Act regulation compliance. So if a tribe, when the tribe is creating their environmental review process, you do not need to follow the stringent NEPA process. However, if the tribe would like to follow that NEPA process, we're fine with that as well. But I just wanted to jump in and say that the stringent NEPA process is not required under the Hearth Act.
Thank you, Suzanne. And I will reiterate that the contact information for all of us and what we do and what division we work for is in the chat. We don't have any questions except one that just came up. And the question is, if a project receives a FONSI or a categorical exclusion, is public comment necessary?
No, public comment is not necessary if there is a FONSI or a CADEX, but that CADEX has got to be listed in your tribal regulations so that we know what your CADEXs are to make sure that you don't have to respond to those. David, if you're on, would you like to make any comments? Would you like to add anything?
No, I think you covered it all, Suzanne. I think that's correct. And I think I'm glad that the question came up without the FONSI and the categorical exclusions, because we've had that question several times beforehand. So thank you.
Yeah, thank you.
Thank you for that question, Mr. Ryan Terry Ryan. Sorry. I also want to point out to and just let you guys know that if you have questions regarding in the field and there's something comes up with a Hearth Act lease for recording or encoding, please don't hesitate to either contact your local agency or region or myself and Carla. If you do contact me, please make sure that the division chief is on the email if you have a question regarding a Hearth Act lease, not a 162, because we have a different specialist who handles surface leasing under 162. But for Hearth only, you may put my name on that email along with the acting division chief, Carla Clark. And with that said, we will end our session with you folks today, and we thank you so much for taking the time and listening in today, and we appreciate the questions. Have a great day, everyone.